Single with no kids in estate planning. Well, if you are single and if you have no kids, you are on the list of people who likely needs to get an estate plan sooner rather than later. And let's talk about why that is. Well, if you were married, for example, you would likely have a joint tenant, your spouse, on your accounts. That way, if something were to happen to you, not only that your joint owner, your spouse, would have access to those funds or to that property to use it for your care, or when you die, that joint owner would likely receive everything. Well, when you're single, it is very likely that you are the only one on your accounts, or that you are the only owner of any real property. Adding someone else to those accounts or to the property, we talked about it in other videos, is not a good idea if it is for estate planning purposes, meaning if you think that it's going to be easier for the other person to have access to these accounts, because there are lots of cons. Watch our other videos on that. But for now, again, if you are single and you have no kids, you need to get an estate plan in place as soon as possible, because you don't have the joint owner protection that comes with the spouse. And if you have no kids, who will step up? That's the thing. If you have kids, even if you don't have an estate plan in place, hopefully one of them or the one that you may have will step up and go to courts, apply for guardianship, and go through probate, whatever the default is when there is no estate plan in place. But when you don't have kids, who would step up to take care of your house, to take care of your pets, to make medical decisions for you, or to make funeral arrangements for you? Just leaving it out there and not caring may be for you, but for most people it isn't. So if you don't have kids, if you don't have a spouse, please start talking to your family members, start talking to your loved ones, start talking to your neighbors, your friends, and see who would step up, who would be interested in serving as your power of attorney, financial and healthcare, should something happen to you where you are still alive but unable to make decisions, unable to pay your bills, unable to communicate with healthcare providers, and so on. Also, if you're not married, if you don't have kids, the law, and if you don't have an estate plan in place, the law has a default, which may or may not be what you would want. So if in Oklahoma, it goes up to parents, grandparents, siblings, and so on. So ideally, if that's not how you want it, if you wanted to give it to charity or to a friend or to a neighbor or to just one person in your family, you have to put it in writing, because that's not what the default says. Every state has their own default rules, so be sure to check with an attorney in your state if you are not from Oklahoma. I hope this video helped. Watch our other educational videos, subscribe to our YouTube channel. We have a lot of information on that. Being single with no kids, again, puts you up on the list of people who need an estate plan in place more than others. Also, be sure to have beneficiaries listed on your accounts, in addition to needing someone to make decisions. Thank you for watching, and see you soon.